Hello and welcome to week 9 of these 5PB webinars. Once again, I'm Andrew Johnson. It's my pleasure to welcome you and introduce you to our speakers. Our first talk today will be from Bennett and Denis Barry. They'll be talking about interviews under caution and prepared statements. Then Richard Padley will tell us that DNA is not only relevant to the resurrection of dinosaurs. Finally, in what's becoming a reoccurring bonus series, Dominic Lewis will provide a brief update on the latest changes to the health protection regulations. As always, please feel free to submit any questions as we go along through the question and answer panel, and we'll seek to answer those at the end. For now, please welcome Bennett.
Good afternoon, everyone. Thank you for joining us. Can I just say at the beginning how unkind both Denis and I thought it was to find ourselves in juxtaposition, or put another way, the war on our backs to Richard Padley's talk about, yes, dinosaurs. Terribly unkind in my case. Denis and I would have preferred titans. We'd have been happy with that, but apparently it doesn't fit with dinosaurs. So here we are. Interviews under caution, pre-prepared statements and no comment interviews. Does one size really fit all? As usual with a Milo and Den talk, we have a subheading, and it could be called this: Answer in haste, repent at Her Majesty's pleasure. When people found out that Den and I were doing this talk, some of our solicitor chums rather unkindly took the view that it was a little rich. Two barristers giving a talk about something which they knew nothing about. Some of our other solicitor colleagues pointed out that it wasn't the first time that Den and I had done such a talk and was probably unlikely to be the last. But what it has already done in speaking to members of chambers and also solicitors is it has brought about a healthy debate. So can I begin in this introduction and telling you what this talk is not about? It's not a law lecture, although there may be a bit of law. It's not a talk saying this is what you should do in any given prescriptive case. It's not a case saying this is what we think you should do in circumstances. The whole point is it's to stimulate discussion and debate about probably one of the trickiest tasks that solicitors dealing with regulatory and criminal legislation have to deal with is, what advice do you give to a client when you're approaching an interview under caution, be it written, which we'll deal with later, or at the police? Well, it's no more than a talk to stimulate debate. Secondly, it's an opportunity to explain the options that one might have and occasionally delve into some examples of cases we've been involved with to see how things played out, both good and bad. In effect, therefore, it's also a reflection from experience. It also recognises, importantly, that hindsight is very powerful when one's talking about this, and what may have seemed a brilliant idea at the time in taking a course of action to interview with your client may, as we've all discovered, on both sides of the solicitor and barrister divide, turn out to be anything but 18 months to 2.5 years later, when your client is being cross-examined in the witness box and really not doing terribly well. There are two other things before we turn to the main slides. Firstly, it's a spot the 5PB logo on the slides. Yes, just to stimulate further debate, there is a competition. There are no prizes. This is 5PB after all. But you are challenged to see if you can spot in every of the next 17 or 18 slides or so the 5PB logo. And if nothing else, and this is the final point before we move to the slides, it's an opportunity on a Thursday afternoon to pretend that you're all working and claim some extra CPD. Next slide, please, AJ. You can all see from here, and there's no point in me reading them out, that there are a number of options that a solicitor faces in deciding what advice to give to one's client in an interview scenario. Before I hand over to Denis, what I'm going to be dealing with later is not just interviews and how they might play out in court proceedings, but trying to look at issues about written representations that solicitors make to regulatory bodies, and also trying to look at the issue of the impact that a client, that an interview decision may have, if not in criminal proceedings, but in professional and regulatory proceedings. So I also ought to say that some people who very kindly tuned in the first time were slightly critical of my lighting. I failed to see how only seeing half my face does anyone a disservice at all. So that's all from me at the moment, more a little later, but let me hand over to Den. But what can I tell you about Denis? Well, some say that he can play The Devil Went Down to Georgia by the Charlie Daniels Band on the fiddle with his eyes closed. Some say he can't play at all. But all we know is he's our Denis and he's a genius. And I never thought I would say this in public, not the fact that he's a genius, but this is the first and I hope only time I say, I really wish I had his hair. Over to you, Den.
Thank you very much indeed, Miles. Can we go to the next slide, please, Andrew? Lovely. What's set out in this slide are things that everyone knows very well. We're dealing with section 34. If you look at the particular slide, there are sections which are words which are more important than other words. So, for example, if you look at the top, which starts at any time, failed to mention any fact. Those words are quite important, relied on in his defence in those proceedings. So mention and fact matter. And then underneath, being a fact which in the circumstances existing at the time the accused could reasonably have been expected to mention. I'll come back to that. And then later on may draw such inferences from the failure as appear proper. So we all know section 34. I wonder if Andrew would be good enough to go to the next slide, please. And just a little bit of background. This particular section came in when Michael Howard was the Home Secretary, and he, for the avoidance of doubt, is the man at the bottom. The Act was rather an illiberal piece of legislation because, among other things, Mr. Howard was concerned to stop were illegal raves that were happening at the time. And above Mr. Howard, or in this particular diagram, perhaps in his head, are the Chemical Brothers, who were famous, among other things, for their track Block Rockin' Beats. I cannot emphasize strongly enough that Mr. Howard is not a member of the Chemical Brothers. He's a member of the House of Lords, and those two organisations are completely distinct. There is no overlap between the Chemical Brothers and the House of Lords, just so that that's clear. If it was a Venn diagram, for example, you wouldn't see any kind of overlap. Anyway, Mr. Howard found two things particularly annoying. Things like block rocking beats, because the definition of rave music included things which were wholly or predominantly characterized by the omission of a succession of repetitive beats. He found that annoying, but he also found defendants not answering questions annoying, hence the legislation. And if you look on the left-hand side of the slide, we can see that the object of section 34 was to deter late fabrication and to encourage early disclosure of genuine defences. And then underneath, in a case called Smith, it was held to give a section 34 direction where a defendant had put forward no more than a bare denial would amount to a direction that guilt could simply be inferred from the exercise of the right to silence. And that's not the purpose of the legislation at all. Oh no, nothing could be further from the case. I wonder if we can go on to the next slide, please. This just sets out really the four main authorities that you might like to have a look at in due course and where you might find it. There's a book called Archbold, which is to be recommended, and section 34 we've just looked at. And there is a quartet of authorities, and when one thinks of quartets, one might think, for example, of famous rocking teen combos, and one of those was Led Zeppelin. And so what I've done is to set out the main 4 authorities in the quartet and then put confusingly underneath Led Zeppelin titles just to remind you about what the cases were all about. So the first one is Argent, and Argent is authority for the proposition that what one needs to look at carefully is the circumstances prevailing at the time which could reasonably have been expected to mean that the defendant would mention the relevant fact. But in the circumstances includes such things as the time of day, the defendant's age, experience, mental capacity, state of health, sobriety, tiredness, knowledge, and personality, which is why you may think very unhelpfully, I've put in a little bullet underneath dazed and confused, because of course many of the people that are represented in police stations fall into that category. And the then Lord Justice, Chief Justice, I should say, Lord Bingham, said when reference is made to the accused, attention is directed not to some hypothetical, reasonable accused of ordinary phlegm and fortitude. I've always thought the expression ordinary phlegm was particularly disgusting in this context, but anyway, but to the actual accused with such qualities, apprehensions, knowledge and advice as he is shown to have had at the time. So to put it in very simple terms, if you're in my position and representing someone, you need to check things like the custody records to see whether he was or she was dazed and confused at the time. Next authority is a case in the Supreme Court called Webber. There is a good piece of good news for defendants in that case and a piece of bad news, which is why in a very clumsy way I've put good times, bad times underneath. The piece of good news is as follows. It was established that rarely, if ever, could a Section 34 direction be appropriate on failure to mention an admittedly true fact. In other words, something which is part of the prosecution case. If you agree with the Crown, then Section 34 doesn't necessarily bite. That is a piece of good news. The bad news in Webber is there can be an adverse inference even if the defendant has not even said anything in the witness box, because facts may be relied on, notwithstanding that a defendant hasn't asserted them in evidence, because a positive case put in cross-examination may be sufficient, and it can even be adopting what the co-defendant said, which is in fact what happened in the Crown against Webber. The next authority underneath is a case called Seaton, which I'm going to go into in a little bit more detail later on, but that's the main authority which deals with privilege and whether you have been consistent with your solicitor throughout the proceedings. Hence, and I think you can see what we've done there, the song remains the same. And then Condren is the main authority about legal advice and remaining silent. It is authority for the what is now fairly obvious proposition that legal advice to remain silent cannot of itself prevent an adverse inference being drawn. Otherwise, there wouldn't be an awful lot of point in Section 34. And so again, you can see that that is the reason why I've rather clumsily put nobody's fault but mine dealing with the authority of Condren. Ultimately, advice is just advice. I wonder if we could have the next slide, please. Thank you. Now, in this particular slide, we can see that there is an image of Charles Dickens. Charles Dickens was mainly well known for having a very attractive beard. It was his best quality. And he also published a book called Hard Times. And in Hard Times, there was a character called Mr. Gradgrind who said, "Now what I want is facts. Teach these boys and girls nothing but facts. facts alone are wanted in life, plant nothing else and root out everything else. And it's difficult to disagree with that as a form of teaching, I'm sure you would all agree. But the reason I focus on Charles Dickens and his excellent beard is because the statutory right to draw inferences is aimed at the failure to mention facts, not mere silence itself. And you can see what I've done there. I've just read out the top bullet. What you may or may not be aware of is what I've also done is simply taken these 4 bullets from the Crown Court Compendium, which gives me the confidence that they are right. But you can see in all of these bullets that they focus on the word facts, much like Mr. Gradgrind would no doubt have done, were it not for the fact that he was a fictional character. Facts may be relied on, notwithstanding that D has not asserted them in evidence. A positive case put in cross-examination may be sufficient. That's the Weber point. And then prepared statements. You can see what it says there. It would be unnecessary for me to read it out. And the same is true for the bullet at the bottom. I wonder if we can move, please, to the next slide, which doesn't have a man with a beard in, regrettably. Prepared statement. Miles is going to focus on prepared statements, but here are some authorities about them. The Crown against Knight, where a defendant had made a prepared statement at interview giving a full account from which he did not depart at trial, there was no room for an adverse inference to be drawn against him. Hooray. However, in the Crown against Turner, Lord Justice Scott Baker said this court notes a growing practice, no doubt on advice, to submit a pre-prepared statement and decline to answer any questions. This, in our view, may prove to be a dangerous course for an innocent person who subsequently discovers at the trial that something significant has been omitted. And Lord Justice Scott Baker gave some advice, which was, no such problems would arise following an interview where a suspect gives appropriate answers to the questions. That rather depends on what your definition of no problem is concerned, because, or indeed what appropriate answers to the questions might be. I've put T against the DPP in because it's an example of a case in the Magistrates' Court. It's a case in which some magistrates made an illogical and nonsensical pig's ear of their reasoning. It's probably the only time this has ever happened in any magistrates' court in the country as a result. Over to you, Miles.
Miles, you may...
No, don't worry, I've realised. Can I have the next slide, please, AJ? Sorry, I was so overcome by reference to beards. So we move on now to pre-prepared statement and no comment. Now look, what's on the screen, can I make it obviously clear, is we're not suggesting, Den and I, that this is an exhaustive list of the pros and cons. But one of the reasons why we decided to put this talk together is, and it follows on really from the case of Turner that we've just seen, that sometimes I think there is perhaps an over-reliance on pre-prepared statements and no comment interviews. And I think some people are concerned about adverse inferences and how it might look to the client if, having given the advice to go no comment, they're then convicted. One of the things I did in putting this talk together was speak to Graham Trembath QC. And we came up with, having done cases together, with the following reality, that when both Graham and I started, there weren't adverse inferences. I can remember when the law changed and we were all appalled, and it was a massive inroad, as we all saw it, into civil liberties and doing away with innocent until proven guilty. But we think that the reality is this: juries seldom, if ever, convict solely because of a no comment interview. The reality is, even if a judge gives an adverse inference, most juries have either, by the time they've heard the summing up, formed a view on the evidence and concluded, one, that the defendant is very, very guilty, in which case the fact that the defendant said nothing in interview makes not a jot, or two, they're really not very sure. And I genuinely think that few juries, if any, say, do you know what? I don't think we're very sure about guilt, but actually, because he didn't answer questions, we're going to convict. So that's how this thing started. And in relation to Turner, and it takes a civil judge like Scott Baker to come up with the analogy using an innocent person. If I may very briefly borrow from a programme in the 80s, not the 9 o'clock news, there was a fabulous sketch dealing with devil worshippers and a very left-wing Anglican priest and how they could all get on together. And Griff Rhys-Jones was playing the role of a devil worshipper and said he liked nothing more than to jump around naked on Hampstead Heath, sacrificing virgins. And then it cut to Merle Smith with his long hair and his dog collar, and he said, yeah, no, actually, theologically, that's quite a tricky one. But there again, what's a virgin? I've never met one. Well, I use that because one could take from Turner, what's an innocent person? How many have any of us attending this seminar or throwing it actually met? I jest. But obviously opportunities, they're on the screen. We'll skip through them briefly, and the old tip at the bottom. Of course, it gives you an opportunity to give, in a more controlled environment, the defendant's account. Both good and bad, I suppose. It then sets the tone, you may think, for the defence case from there on in, if there is a prosecution. And of course, and Den's going to concentrate on recent fabrication a little later in the talk, but having got it down, it prevents the suggestion of recent fabrication and the opportunity for the prosecution to put that at trial, providing, and this is the point which Turner was making, providing it's really detailed and things are not missed out. What are the cons? Well, let's take a health and safety case where there's a death and it goes to the police first because they had primacy of the investigation. And what tends to happen is with a very short period of time, the police invite potential suspects in for early interviews. Sometimes they really haven't got to the bottom of the investigation. They may not even have a cause of death. They may be waiting for experts' reports. But it's a tactic they use to see if people are willing to open up and discuss. And one of the cons of pre-prepared statements might be, is it too early to give an account? In particular, has there been sufficient disclosure? Other problems arise, perhaps with an over-reliance on the veracity of a client. All of us, I'm sure, can recollect cases where the defendant was convincing in the fact that he was telling the truth and therefore a pre-prepared statement is given, only to find that 6, 9, 12, 18 months later that he was lying like a trooper, dealing with the defendant and the pre-prepared statement and the misery and fallout that follows. But the other point is, it doesn't just depend on the veracity of the client. We all know in our own experiences, whether it's seeing someone in the street, that we can be adamant that we've got something right and subsequently proved to be mistaken. Other cons, well, I've dealt with it already, dangers of the lack of detail and later inconsistencies. And actually, I did some Googling, and if you look at the National Police College's advice on pre-prepared statements and how to deal with them, it encourages officers not to dissuade a defendant. And they say the advantage of some pre-prepared statements is once you see which line the defendant's taking, it may actually speed up the decision to charge or prosecute clients. Tip, shameless plug at the bottom. We all recognise that when you're summoned to the police station, and you may not have much time to deal with the defendant, and you're probably being given limited disclosure anyway, that trying to take a decision is, as I've said earlier, probably one of the more tricky decisions that solicitors have to take in relation to litigation. Sometimes, not always I accept, but sometimes 2 minds are better than 1. And do not be afraid to pick up the phone and telephone counsel who is 1 step removed and discuss the issues with them. So that if nothing else, if there's a complaint about the advice you gave later, when the defendant's convicted, you can always join counsel into the complaint as well. Next slide, please, AJ. AJ? Next slide, please.
You should be seeing the next one.
I've got it now. Thank you. Yes. Pre-prepared statement and answering questions. Well, it's a tactic. I've put here, it provides consistency and grace under pressure. It can create a particularly solid impression with a jury, because sometimes I think that jurors question, especially if it's a professional person, well, why is it that he's prepared to give a pre-prepared statement and then hide behind a cloak or veil of silence? It can also look good, and I'll return to this later when we deal with the fallout of interviews and disciplinary proceedings for professionals. It can also look good later. Some disciplinary bodies are not massively keen on their members, even when they're at risk of being charged with criminal offences, from keeping stum. The cons, well, they're there again. Adequacy of disclosure. Well, that's something that all of you will be familiar with. It seems to me that disclosure from cases I've dealt with recently, provided either by the regulator or by the police, and by the regulator, if there's any, it's almost non-existent, has got less rather than more as the years roll by. Also, if you allow him to answer questions afterwards, there is always the danger of a client who is far cleverer than he thinks he is, getting it wrong, and you watch the account that's been prepared unravelling before your eyes. You're also, if you answer questions and give a pre-prepared statement, a potential hostage of fortune to further evidence. As a tip, and it may be a pretty obvious one, best reserved for cases where clients are 100% sure he or she is innocent, and also in a case where what you're really looking to do is to show the fallacy behind the complainant's account and to encourage the police, stroke the CPS or the regulator or the HSC not to prosecute at all. Thank you, AJ. Next slide, please. Now, this tends to occur nearly all the time in this days in regulatory proceedings, HSC prosecutions, trading standards prosecutions, and the like. On the face of it, it's the most attractive of the options that you can have. It allows, for instance, for preparation in more detail. It may mean that because you get the questions set out in advance, the prosecution are forced to reveal more of their hand than they would like to or would otherwise have to. It also can, in a good and strong case, provide a detailed basis from which you can prepare the defence case. And it may, when they have a 10, 15-page response question, discourage proceedings from being instigated at all. But there are problems. It is absolutely crucial in providing written answers that they are accurate. Equally, you cannot pick and choose, well, you could, but if you pick and choose to answer some of the questions and stonewall or avoid the more difficult ones, one of the issues you will have is the risk of an adverse inference. Also, sometimes, especially when there may be a defence of due diligence available to you, by actually agreeing to respond and bearing in mind, although there may be an adverse inference even in written interviews, if you don't, no one can force you to respond at all. You can reveal to investigators that you don't have a due diligence system at all, and that's all they're really worried about. And the only thing that was stopping them from prosecuting was the worry that you might have a defence. Just an example of why sometimes it's all right not to give written answers, and even invited, tell them to go away. Some time ago, you may recall that a number of outlets, some of which are supermarkets, were having problems with the discovery of horse meat in some of their products. Well, one particular supermarket, and unusually for me, they will genuinely remain nameless, was being investigated by a county council trading standards department because horse meat had been discovered in their own brand corned beef. Putting aside the fact that there were detailed internal discussions about whether, in fact, there was greater nutritional value now in the product with the inclusion of horse meat than without it, one of the decisions was taken as to whether one should answer questions. A letter had been sent at the very beginning saying, look, these are our suppliers. We've now found out that they were buying, unbeknown to us, from people in Romania. We carry out regular audits, that's our position. Not surprisingly, local authorities said, well, we'd quite like to ask you a number of further supplementary questions. We want to know, for instance, what your turnover is. We want to know how many products you've sold. And you could see very quickly, as an advocate, where this line of inquiry was going and whether someone would be thinking of pursuing confiscation proceedings at the end of a prosecution. Now, this particular supermarket's policy was at all times it would endeavour to be cooperative, and at all times it would endeavour to answer questions in writing. And the solicitor and I formed the view that that would be semi-disastrous in this case, and we advised them that they shouldn't engage any further. Now, that caused such consternation that there were even conferences with board members because they were worried that it would be seen to be uncooperative. The net result is the local authority were told where to go. We simply said, you've got our representations, there's no point in asking us any more questions. You want to go and prosecute on the basis of that, you go right ahead. But if someone is determined to sabotage the food chain, there's not an awful lot we could do about it. Thank you very much indeed. Decision at end of case, no prosecution. So this is the point of the talk. Does one size fit all? Should you always give written answers or pre-prepared statements? No, not necessarily. And it is abundantly clear to all of you watching, I suspect, it is so dependent on the facts. Next slide, please, AJ. There is one thing I want to deal with briefly on this. I'm not going to read it out because I get the point that A, it's on the screen, but also that quite often what the client really wants, really wants, zigzag, etc., it is for there not to be a prosecution at all. Sometimes, though, clients just don't get what they want, and you have to advise them that it's almost inevitable, depending on the circumstance of the case, that there will be a prosecution. Now, a tip, and I discovered this last year in a case in Wales. That's all I'm going to say about Wales. But it was a health and safety prosecution. And the clients hadn't been invited for an interview. They were a crane company called TJ Crane Hire Limited. And there were a number of other companies potentially in the frame for a non-fatal accident, which intended to a worker on site. The HSE never asked us for an interview. In fact, the client's instructions were that throughout the investigator had said, gosh, this is jolly bad luck. Don't worry, you are not going to get prosecuted. Then at the end, they wrote to the client, who, for reasons best known to themselves, did not even refer the letter to the solicitors that were instructed and on record. The letter said, now, here it is. We suspect that you have committed a number of regulatory breaches, and it set out what it was. We're coming to the conclusion of our investigation, and we invite you to make any written representations you would like. First point, it was clear to us that the HSE had concluded, rightly or wrongly, that they suspected that the company was guilty. Secondly, and I thought quite importantly, there was surprisingly no written caution in the letter. The clients sent a response which they thought was clever, but was potentially semi-disastrous, because the issue in the case, in a nutshell, was this a crane being hired for someone else to organise the lift, or was it being hired with a crane lift, which would have meant that our company would have been responsible for setting out the risk assessments and managing the whole project. When it came to trial, we challenged the admissibility of the written representations. The first argument we came up with, which we thought was good, but which the judge thought was pants, was this is a breach of Code C because there was no caution. Even if it's a written letter, there still needs to be a caution if you're inviting responses. But what we stumbled upon, it's no more than that. It was pure fluke, doing the last bit of the research on the submission on exclusion of evidence the night before making it, that I went through the HSE website. If those of you want to make a note, because I'm not very good at putting hyperlinks, were you to go onto the HSE website, you would see that there's an element that says putting together the prosecution report. If you click on that and then go down to the section that says views of the potential defendant, there's a section that reads this. There are 3 paragraphs, 14, 15, 16, and I needn't read the first 2. But what they summarize is, if there hasn't been an interview at all, or if there's been an interview under caution some time ago, it's perfectly permissible to write to a suspect, inviting them to make written representations before charge. But here's the rub. Paragraph 16 of that section says this: where written representations are received, they should not be treated as evidence against the person supplying them. They may, however, be useful, for example, in revealing further lines of inquiry, informing you of matters that may be relevant, and providing information on which you can exercise the public interest stage of the decision. Now, I hadn't come across that provision before. What was interesting, it was clear that the prosecuting barrister hadn't come across it before, nor his HSE external solicitor, nor indeed the HSE investigator. And the judge said, look, I'm not really troubled whether there's a breach of the codes. I don't have to rule on that. Their own guidelines say it shouldn't be admitted in evidence. They've admitted in evidence. I take Mr. Bennett's point. They hadn't given them an opportunity to be interviewed and ask questions, so I'm going to exclude it. Now, I checked last night and this morning, and it's still there. And I say that because this case took place in Mull Crown Court in April. And I wondered whether, as a result of that, whether they'd have the presence of mind to go back and at least delete that reference. So just remember this: if you do make written representations, if you're minded to at all, if you're then prosecuted, don't feel abashed at turning around and said, very disappointed to see this in the bundle because it's against your own guidance. Now, there may be an answer to that, playing devil's advocate, which I'll deal with a bit later. Over to the next slide, please, AJ. Here's something that I'm sure you're all aware of, and even if you couldn't tell why there was in effect a risk against, there was no such thing as a without prejudice letter in criminal proceedings. At common law, if a solicitor made an admission either at the police station, for instance, or in correspondence on behalf of the defendant, it was admissible until the defendant was able to show that either it was inaccurate or that the solicitor stroke agent had no power to make that representation at all. And what you can now do is find solace in this. Any rule of law under which in criminal proceedings, section 118, subsection 6 of the CJA 2003, an admission made by an agent of a defendant is admissible against the defendant as evidence of any matter stated. Now, the alert amongst you will think, but hang on, Milo, I just thought you told us that written representations aren't admissible. Fortunately, rightly or wrongly, in the argument against me in North Wales, no one spotted this. I think there would have been a counter argument that even if it's against the guidelines, guidelines are there to provide a guidance, and this is primary legislation. The difference here would have been, in my case, that it wasn't made by the solicitor. But just be aware that there are provisions that mean that anything you write can be held against not just you, but more importantly, to your client. Next slide, please. This comes to the end of my part of the talk. One of the difficulties for solicitors in this area is this. You may succeed in your client giving an account which leads the Crown Prosecution Service, for instance, to take the view that there is not a realistic chance of gaining a conviction. But they are then handed over to the GMC immediately, and they are admissible in disciplinary and regulatory proceedings. And therefore, as I've said, Hobson's choice Do you tell all and answer questions or give a pre-prepared statement that may prevent you being charged on the one hand, but sadly lead to the speeding up of disciplinary proceedings? And although your client may avoid a criminal prosecution, he may not thank you very much if the decision was taken ends up in such a way that he finds that he or she has been erased from the register. As we said at the beginning, there are no hard and fast rules. These are, as I said, to stimulate debate. And it's quite right that counsel has the luxury of hindsight and mulling over points later when new solicitors are at the coalface. And that's why I put, and it's a rhetorical question, who'd be a solicitor? Over to Den, and next slide, please.
Thanks very much, Miles. Following on from what Miles has just said, when we were preparing these talks, we obviously spoke to a large number of our solicitor friends. And just dealing with the next slide, there are obviously circumstances in which it is a good idea to have a comment interview. And what I want just to set out is some of the things that I was told by professional colleagues, solicitors, when they knew I was preparing this particular talk. Because the thing which was emphasised to me was it rather depends on what your central objective is. Because it may well be that what you want to do, in fact, is to make the case go away, and that if you comment during the course of the interview, you may be able to achieve that, particularly if it's a detailed account. But there may be cases where what you're mainly concerned about is not to be caught out in a lie, in which case, obviously, you're running a risk if your client comments during the course of the interview. So the factors in play, it was suggested to me, are as follows. Is whether the interview's on notice or not, what's the quality of the pre-interview disclosure, who's the prosecuting authority, how well resourced are they, which other authorities are involved in the background, for example, HMRC. How complicated is the case? If your case is alibi, why not tell the police? And in respect of what you want to achieve, it may well be that you have been tipped off by the prosecuting authority about how they see a particular case going. So, for example, you may be told by an investigating officer that if a half sensible account is given by your client during the course of a comment interview, they will either, on the one hand, perhaps consider a caution, or they may not be thinking of investigating further. So those are some of the pros and cons about a decision to comment. Could we have the next slide, please, Andrew? This is the sort of traditional approach, no comment, no prepared statement. For people watching this talk who are not necessarily as old as myself and Miles, you may not recognise the man on the right-hand side. His name was Stefan Kishko. He was arrested in 1975 for the murder of Leslie Anderson, who was a child in pretty grim circumstances. And whoever murdered Leslie Anderson was not Kishko. For reasons I won't go into because they're a bit grim, he would not have been physically capable of one of the things that the murderer did. And so said Lord Lane during the course of the appeal. Mr. Kishko had the mental age of a 12-year-old and confessed after 3 days of interviewing. He served 16 years in prison and died 2 years after being released. It's worth remembering sometimes why the Police and Criminal Evidence Act came in. It was for people like Stefan Kishko. And so there are reasons not to engage. Overwhelming guilt, innocence and danger of being framed, untrustworthy disclosure by the police, the vulnerable defendant, a complex allegation over a number of years. Miles has alluded to what juries, the way they may well approach a no comment interview in a complicated case. A complex allegation with a number of investigating bodies. And another factor, of course, is what are the co-defendants going to do? So factors that you might like to consider are If the case is complicated, will the jury really hold it against your client if he goes no comment? If your client is vulnerable, you obviously have a duty in lots of circumstances to make sure that he or she doesn't say anything. And if you've asked questions before the interview of the prosecuting authority which haven't been satisfactorily answered, are the jury going to hold that the no comment against your client? Probably not, would be the experience of myself and Miles. Can we go to the next slide, please? Now, a slightly lighter note. This gentleman is mainly on the screen, of course, because he's bald, and it's a very good look, I'm sure you would agree. And underneath we can see that it says self-serving statement. It's regrettably not completely unknown for individuals who've been involved in regrettable behaviour to feel the need to explain what they've been doing 2 months later. Now, obviously, the problem with such documents is that there is a danger that people might think that you're making up an account to suit your own purposes. And a document which is created after the event, designed to demonstrate the innocence of an individual, but which makes no admissions or inculpatory remarks, is a document which, as a matter of law and a matter of common sense, is worth an awful lot less than one which is made contemporaneously. That is the law. They are known as self-serving documents. And there's an authority about how self-serving documents are dealt with, which is the Crown against Sharp, which is 1988. And the Court of Appeal said the longer the time that's elapsed after the first encounter, the less weight that will be attached to the denial. And they also said there may be a rare occasion where an accused, a hypothetical accused, let us say, with not very much hair, produces a carefully prepared written statement with a view to its being made part of the prosecution case, which is largely self-serving. The law is that a trial judge would plainly exclude any such a statement as being inadmissible. And the reason, as a matter of logic, is because if you construct something after the event, it just doesn't really have very much weight. Can we have the next slide, please? The same gentleman again. So the case of, I think his name is Mr. Cummings, neatly encapsulates some of the tactical problems that we've been discussing, because they are the decisions that you have to make about advising your clients in police stations are the kinds of questions that juries may ask of your clients. Will the tribunal think that you've only just made up your account? Will they think that you weren't prepared to give your account before because it is fairly obviously untrue? If you're thinking of using a prepared statement, why do you need to have it all written down for you, perhaps by a lawyer? And if you are quite sophisticated, was it unreasonable for everyone to expect you, in the words of Sly and the Family Stone, to sing your simple song before? So this bald gentleman demonstrates perhaps the difficult decisions that you have to make representing people during the course of interviews and thereafter. Could we go to the next slide, please? I'm going to deal with this very briefly. This is, you may recall, one of the quartet of authorities. This is The Song Remains the Same, or Seaton. Legal professional privilege is of paramount importance. In the absence of waiver, no question can be asked which intrudes upon privilege. A defendant is perfectly entitled to open up his communications with his lawyer, and it may sometimes be in his interest to do so, particularly if, to quote Robert Plant and Jimmy Page, the song remains the same. But if we go over to the next slide, please, Andrew. one of the questions, if one does that, is how far has privilege been waived? He does not automatically make available to all other parties everything he said to his solicitor. He may well not even be opening up everything said on the occasion of which he gives evidence. The test is fairness and/or the avoidance of a misleading impression. And the test on the law is that the defendant should not, as has been put in some of the cases, be able to both have his cake and eat it. Unlike the Prime Minister, who we know, do we not, is famously pro-cake and pro-eating it. That is not the law as far as Seaton is concerned. Back to Miles, please.
And there we go, Miles, if you want to unmute yourself.
Yeah, one day I'll unmute. Final slide, which in effect brings us to the end. Firstly, you will see that the question we posed at the beginning was, does one size fit all? And it was a rhetorical question, really, because the obvious answer is no, it doesn't. I hope that's been informative. I've been Miles Bennett, he's been Denis Barry, and for the rest of the talk, and I'm sorry that we've overtaken with a bit of what I like to call Fergie time, but you're now going to hear from some really clever people. Thank you very much for tuning in and listening.